Well, we'll turn our attention now to the judiciary. I mean, yes, a very important arm of government. We're joined this morning by Mr. Richard Nwankwo, who is of the Crusade for Justice. Thank you for coming on this morning.
Thank you very much.
Well, we've been focusing on the reforms in the judiciary for some time now, and lots of people have spoken about the criminal justice system. They think that, look, if there's a reform in that respect, I mean, so many moments of respite would have come the way of Nigerians. All of those cases that are still pending for several years would have been seen through. Do you share the same concern?
Well, I think the reforms fall, is in tune with the sentiments of every lawyer and every right-thinking member of the society. We quite appreciate the difficulties that are inherent in the judicial system, and that occasionally that plays out, and that is what we are seeing in some jurisdictions now. And I believe that a lot, ought to be done. All hands should be on deck, especially from the perspective of the judiciary, and we believe that that is presently being done, but the pace at which these reforms are going on it's not something to write home about.
Well, how does the comment from the CJN sit with you when she talked about this massive grab between the clerks, the bailiffs, registrars? Have you experienced any of such?
Well, I think she actually said the obvious, but I also believe that she should have gone beyond that, because I believe that there's a lot of corruption going on also at the bench, and we believe that the judiciary must fall back on the in-house cleansing system to purify some of these things. But at that lowest segment, at the level of clerks and registrars and all that, it is pretty embarrassing at this stage, and we see that play out in virtually all the courts in all the jurisdictions in Nigeria. And we have always maintained that the first thing must be done first, and that is constant training and retraining. And also we have to take into consideration the fact that the welfare package of some of these judiciary workers must also be captured in a very brilliant manner. Otherwise, we'll still have snippets of indices of corruption as it is currently playing out.
So if that is the case with the judiciary workers, how do you then justify what you say is going on with the bench?
Well, it is not a new phenomenon. I think this phenomenon, or this issue of corruption, is not new, because that is exactly what we have been, campaigning against over the years. And of course, you remember some years back when over 30 magistrates were relieved from their positions. It's as a result of massive petitions and campaigns from civil society organizations, and of course the Kejaba was at the forefront of that battle. And that is also being replicated in some other jurisdictions. I think what we should focus on now is in bringing in new blood into the judiciary, especially at the lower segment, that the system must be open, the system must be transparent, and the issue of integrity must be elevated to a critical level, so that we just don't bring in anybody into the bench. And of course, there are a whole lot of political appointees at the bench, and that makes nonsense of the entire process. We believe that the process of appointment must be isolated from the ambience of the executive, and if that is not done, we will still continue to model in the kind of mess we have now. And of course, there are so many segments to it. You don't look at some of these things in isolation. We are talking about roadworthiness of vehicles. You must also talk about roadworthiness of the drivers. I believe that some of these things have isolated ambience. We must have to look at it from a very holistic and comprehensive manner.
When you talk
Otherwise, it will be difficult.
Mr. Nwankwo, when you talk about appointments, we've also highlighted this the last time. But again, if you look at it, does that in any way tell us about the freedom or determinism of the judiciary in this whole equation?
Well, it is extremely difficult to isolate the sources of that process from a purified system of appointment. The system of appointment must be ebullient, and that is what the NBA, particularly at this present period, is doing. We are trying to have to badge into the process and make sure that we have very strong input. And the Lagos State government has always bought into that arrangement, where the members of the leadership of the bar from various branches are meant to be, their views are captured in their appointment process. And we want this to be replicated in other jurisdictions. And we want this to be the hallmark, because those of us who are in the field we tend to know who and who are good, even amongst us. And the same thing applies to even to the elevation, to the rank of senior advocates, when lawyers do not have any input. So these are issues that we believe that must undergo very stringent reform system.
And we know all of these, but we haven't actually tweaked that when we talk about amendments of our constitution, so that we can actually free it up and let it have that freedom it's always desired.
Well, of course, you know that part of the challenges we're having under this present dispensation is the difficulty in effecting some of these amendments. Of course, you saw how it played out even in the creation of local government areas. Some of these things are constitutionally, designed in such a way that it will be extremely difficult for whoever wants to effect a change.
Intentionally.
But that is what the Constitution says. But we believe with the total and comprehensive involvement of all the stakeholders, that it will be a lot easier. And that is what we are agitating for, that some of these processes must be refined. And core practitioners and those who are in the industry should be allowed to have a say in some of these appointments. It is usually ridiculous when you sit down and people are appointed and you're hearing the names of some judges for the first time. Judges, you don't know their practice history, because the Constitution never stipulated that it should be in practice. The Constitution says that so and so person should be a lawyer, must have spent a minimum of 10 years maybe at the bar. The same thing even when you're going to the uppermost court, that you must have spent about 15 years. They don't want to know whether you've been in practice, whether you've been operating a restaurant, or whether you've been running some garments industry. So that is what is playing out. And of course, you know that some of these appointments are political sacrifice that are being brought into the system. And when this happens, it continues to regurgitate. And one runs into the kind of challenges we are seeing in some jurisdictions now. And of course, on the part of the litigants, the education must be comprehensive, must be across the board. It is not something you focus on the registrars in the court or the court clerks or all that. It must be comprehensive, because when you deal with these things in isolation, you find out that you will definitely not get some results that will be encouraging.
How will you describe the kind of challenge that the judiciary is facing in Ekiti?
Well, what is playing out in Ekiti, I think, to my mind, I think we are just seeing a reversion of trying to deal with the 21st century problem with probably an 11th century machinery. That is just what is playing out in Ekiti, and it leaves much to be desired. In fact, when I read that for the first time, I was extremely saddened, because it's a sacrilege. It is an anathema. It is something that it is repulsive, and it has the capacity to send the wrong signal, to the international community. And that has already happened, because even on my way to this place, I got a call from outside this country. An inquiry was to confirm whether this is they're seeing actually real. But you see, some of these people do not understand the magnitude of what they are doing. The demonization of the judiciary, the animalization of the process. And of course, you know that there is a radical incentive over the years, and I have consistently said that. When there is no sanction system, you don't expect anything to work, and nothing will work. So how do you explain a situation like this playing out, and you see mobile police people there, instead of making efforts to arrest the people that are dropping tear gas within the vicinity or within the premises?
Is